Move away cases can be one of the most stressful situations a man can go through in family court. Whether your co-parent wants to move across the country or just one county over, it can be very difficult to deal with the thought of your child moving further away from you. Today, we'll go through the factors the courts look at in these cases. Hi everyone, I'm Mark Real Jr., the Fathers Rights Attorney, and if you're navigating the complexities of family court in California and the topic of a parent wanting to move away with a child has come up, you're in the right place. Before we dive in, if you are a father facing divorce, a child custody issue, or anything involving family court, give me a call at the number in the description or click the link to schedule a time to chat with someone on my team in a free, no obligation case evaluation, where we can help determine how we can help you navigate the family courts. In California family law, when parents share custody of a child and one parent wants to relocate a significant distance, often out of state or far enough within the state to disrupt its current custody schedule, it's considered a move away case. These situations can be emotionally charged and legally complex, as the court must balance the right of the relocating parent with the paramount concern, the best interest of the child. Let's clarify exactly what constitutes a move away in the state of California. It's generally understood to be a change in the child's residence that would substantially impair the non-relocating parent's ability to exercise their custodial rights. This isn't just about a parent moving a few blocks away. It typically involves one of three scenarios. Number one, the most common, relocating out of state. Moving the child to a different state is almost always considered a move away. Number two, relocating a significant distance within California. Even in the state, a move that makes regular visitation and the current custody schedule impractical can be deemed a move away. This might depend on factors like travel time, the child's age, and the existing custody schedule. And number three, any move that necessitates a substantial modification of the current custody order. If the move requires a complete overhaul of how the parents share time with the child, it will likely be considered a move away case. It's important to note, a parent has sole legal and physical custody. The custodial parent generally has the right to change the child's residence subject to any existing court order. However, even in sole custody situations, the non-custodial parent can petition the court to prevent the move if they believe it's not in the child's best interest. The LaMusha factors, which we'll go over here shortly, would still apply and be relevant in such a dispute. The guiding principle in all child custody matters, including move-away cases, is always what is in the best interest of the child. To determine this, California courts rely on a specific set of guidelines. The landmark case for move-away situations is In Re of Marriage of LaMusha from 2004, and it laid out 17 broad factors that the court should determine when deciding a move-away. These 17 factors are often referred to as the LaMusha factors, and they include the age of the child, the health of the child, the emotional ties of the child to each parent, the ability of each parent to provide for the child's emotional needs. Number 5, the ability for each parent to provide for the child's physical needs, the child's involvement in school and community activities. Number 7, the child's preference, if the child is of sufficient age and maturity. Number 8, the history of domestic violence by either parent. Number 9, the habitual or continued abuse of alcohol or controlled substances by either parent. The willingness and ability of each parent to facilitate and encourage a close and continuing relationship between the child and the other parent. Number 11, the geographic proximity of the parents to each other as it relates to facilitating visitation. Number 12, the best interest of the child. Number 13, the sex of the child. This is generally considered a neutral factor unless there is a specific reason related to the child's well-being. The race or ethnic background of the child or parents. Again, this is generally considered a neutral factor unless there is a specific reason related to the child's well-being. Number 15, religious beliefs of the child or parent. Again, generally considered a neutral factor unless there's a specific reason related to the child's well-being. Number 16, the financial status of each parent. And no, this isn't the wealthiest parent. This is considered in terms of the ability to provide for the child's needs. And number 17, any other factor the court deems relevant to the best interest of the child. These factors, which are also largely reflected in California Family Code Section 3011, help the court evaluate what living arrangement and parenting plan will best serve the child's overall well-being. The court will weigh these factors carefully in move-away cases, considering how the proposed relocation might impact the children. Now that we understand what constitutes a move-away and the key factors the courts consider, let's dive deeper into how these factors are applied in practice. The judge will simply not tally up factors. Instead, they will conduct a nuanced analysis of each factor in relation to the specific circumstances of your family and of your case. One of the most significant factors is often the child's preference, especially as they get older and more mature. While a child's wishes are not the sole determining factor, the court will give them due weight considering the child's age and maturity. Next, the stability of the child's current living situation is also a crucial consideration. The court will look at the child's ties to their school, their friends, the community, and assess the potential disruption a move could cause. Next, the reason behind the proposed move is also extremely important. If the relocating parent can demonstrate a genuine necessity for the move, such as a job opportunity or to be closer to family support, the court will take this into account. However, the court will also scrutinize the motives to ensure the move is not intended to frustrate the non-relocating parent's visitation rights. The relationship between the child and each parent is also another critical factor. The courts will assess the emotional bond the child shares with each parent and the impact the move could have on these relationships. The willingness of the relocating parent to facilitate an ongoing contact with the other parent is also heavily weighed. And finally, a key factor, the court's going to consider any history of domestic violence or substance abuse by either parent as to the child's safety being paramount. Move-away cases are highly fact-specific, and the outcome will depend on unique circumstances of each family. If you are facing a move-away situation, it's crucial to seek legal counsel from an experienced California family law attorney who can help you understand your rights and advocate for your interests, and most importantly, the best interests of your children. They can help gather and present evidence related to the LaMusha factors and navigate the complex legal procedures involved. Remember, the court's ultimate goal is to ensure the child's well-being and make a decision that serves their best interest in the long run. Thank you for watching. If you found this video helpful, please like and subscribe for more content just like this. And if you have any questions or would like to share your experience, please leave a comment below. And if you comment RFR, our team will reach out with how we can help you successfully navigate the family court system.